The U.S. Supreme Court has agreed to hear oil companies' arguments that they shouldn't have to stand trial in a climate accountability lawsuit, setting the stage for a ruling that could decide whether similar lawsuits across the country are allowed to move forward.
The lawsuit in question was filed against Exxon Mobil and Suncor Energy in Boulder, Colorado. It's one of dozens of cases arguing that oil and gas companies deceived the public about climate change for decades and should now have to pay for the resulting damages, like Colorado's deadly Marshall Fire that burned down more than 1,000 homes. For years, the Supreme Court rejected Big Oil's request to review similar cases. So what's changed? For one, Justice Samuel Alito didn't sit out from hearing this request, even though he's sat out from hearing these cases in the past, since he owns thousands of dollars in stock in ConocoPhillips and Phillips 66. Those companies are defendants in other climate accountability lawsuits whose fate could be determined by a ruling in Boulder's case. Other justices now on the bench have ties to Big Oil, too. Big Oil's Supreme Court play is part of a larger effort by the oil industry and its allies to shield oil companies from these lawsuits. They've been ramping up the pressure on lawmakers, too. Representative Harriet Hageman said she was crafting legislation that would shield oil companies from climate lawsuits. But the justices seem to not even agree on whether they have the authority to rule on oil companies' arguments before a trial. It's a question they ask both sides of this case to answer. Whatever the court decides could have a major impact on the dozens of states and communities fighting in court right now to hold fossil fuel companies accountable.